I'm Irin Carmon. I'm the co-author of Notorious RBG, The Life and Times of Ruth Bader Ginsburg. And I'm going to be reading an excerpt from the dissent in Gonzalez versus Carhart, one of the major abortion decisions in which RBG was in the minority. Okay. As Casey comprehended, at stake in cases challenging abortion restrictions is a woman's control over her own destiny. There was a time not long ago when women were regarded as the center of home and family life, with attendant special responsibilities that precluded full and independent legal status under the Constitution. These views, the court made clear in Casey, quote, are no longer consistent with our understanding of the family, the individual, or the Constitution. Women, it is now acknowledged, have the talent, capacity, and right, quote, to participate equally in the economic and social life of the nation. Their ability to realize their full potential, the court recognized, is intimately connected to their ability to control their reproductive lives. Thus, legal challenges to undue restrictions on abortion procedures do not seek to vindicate some generalized notion of privacy. Rather, they center on a woman's autonomy to determine her life's course and thus to enjoy equal citizenship stature. Ultimately, the court admits that, quote, moral concerns are at work, concerns that could yield prohibitions on any abortion. Notably, the concerns expressed are untethered to any ground genuinely serving the government's interest in preserving life. By allowing such concerns to carry the case and day, overriding fundamental rights, the court dishonors our precedent. Revealing in this regard, the court invokes an anti-abortion shibboleth. God, I hope I'm pronouncing that correctly. The court invokes an anti-abortion shibboleth for which it conceitedly has no reliable evidence. Women who have abortions come to regret their choices and consequently suffer from, quote, severe depression and loss of esteem because of women's fragile emotional state and because the, quote, bond of love the mother has for her child, the court worries. Doctors may withhold information about the nature of the intact D&E procedure. The solution the court approves then is not to require doctors to inform women accurately and adequately of the different procedures and their attendant risks. Instead, the court deprives women of the right to make an autonomous choice, even at the expense of their safety. This way of thinking reflects ancient notions about women's place in the family and under the Constitution, ideas that have long since been discredited. Though today's majority may regard women's feelings on the matter as, quote, self-evident, this court has repeatedly confirmed that, quote, the destiny of the woman must be shaped on her own conception of her spiritual imperatives and her place in society. In sum, the notion that the Partial Birth Abortion Ban Act furthers any legitimate government interest is quite simply irrational. In candor, the act and the court's defense of it cannot be understood as anything other than an effort to chip away at a right declared again and again by this court, and with increasing comprehension of its centrality to women's lives.